Thank you very much for the introduction. Federation President Jenny and beloved sister-in-law, International President Yvonne, members of conference. I am delighted to be able to speak with you. Delivering the difference is something which I've personally attempted to do for many years. I'm not sure that I've necessarily succeeded, but I've tried. Now, I would like to invite all those who are able to stand when I ask, and those who are not able to stand, if they could raise their hands. I would like anyone who is wearing glasses to stand. Anyone additionally who has been to university? Anyone who can speak a second language? I have some very bad news for you. Well, firstly, could you sit down? And then, is there anyone who did not stand? If anyone did not stand, if they could now stand, thank you. Those who stood, I'm afraid, fell within the class of people who would not have survived the Khmer Rouge regime. Those who stood, or are standing now, you may have survived, you may not, because in fact the class was much larger. If you had ever worked for a government, if in fact you had secondary education, if you were associated with the armed services, your chances of surviving the Khmer Rouge regime were very slim indeed. Now, I was a member of the extraordinary chambers of the courts of Cambodia for 8.5 years. It was a hybrid national and international court, and it considered the most heinous crimes known to mankind. The Khmer Rouge were in power for 3 years, 8 months and 20 days. And during that period, they turned Cambodia not into a failed state, but rather a shattered state. There was no government at the end of it. There was no money. There were no systems in place. People were left to merely survive. When the Vietnamese came and, in effect, rescued them, there were between 1.8 and 2.5 million people who had been killed. 1.3 million of those people are estimated to have been tortured to death. The rest were overworked to death. Now, the system of law that we had to work with in Cambodia in the trials was a French-based legal system, which was imposed upon the tribunal as a result of an agreement between the United Nations and the Cambodian government. And I'll just briefly explain how it works, or didn't work. There are both national and international judges who sit on the court. The court has an investigating judge, or 2 investigating judges, 1 Cambodian, 1 international. The investigating judges receive a file from the prosecutors who have already carried out an investigation. They then undertake a re-investigation looking for inculpatory evidence, that's evidence that will show guilt, but also must look for exculpatory evidence, that's evidence that may lead towards innocence. And then ultimately they present a file with the charges. And in the first case, there were some 500 pages in this file, together with an additional 5,000 footnotes, which in turn related to other files. Then the matter would go before my court, which was called the pre-trial chamber, which was actually the an appeal court, but also determined the issues of law. And we were stuck between, or the law as it was, between 1975 and 1979. That was the relevant law. And at that point, the legal system internationally was still stuck back in the Nuremberg period. So we had a limited legal regime, and quite often there were gaps which we had to fill. When the Khmer Rouge took over, they moved into Phnom Penh and they said to everyone, the Americans are attacking, you must leave. You will be able to come back in 3 days. Don't take any possessions with you, just a little bit of food, and leave. Anyone who refused to leave was shot on the spot. The people who were in the cities were referred to as the new people. I sensed that everyone here would fall into the category of new people, or most. If, however, you were a peasant farmer, you were the old people. And the new people were the city dwellers, the business proprietors, anyone who was educated. And it was assumed that someone who had glasses was educated. I'm not quite sure why. So they then forced people out into the countryside, into the villages, and they were forced to dig canals by hand, to dig dams by hand, to make airstrips by hand. They were underfed, overworked, and died whilst working. It was an absolutely horrific situation. There was so little food that many of the guards actually ate body parts from those people who they killed, which was just appalling. The court has had so far 2 completed trials, and it has a continuation of a trial now, and then it will have another 3 or 4 trials to follow. The first trial involved a man by the name of Duik, and Duik was the head of S21, and if any of you have been to Phnom Penh, you may have been there. It's the most horrific concentration camp. In that camp, some 20,000 people were killed. Duik was found guilty of the murder of 12,272 named people, but in total, as I said, 20,000, and he was sentenced ultimately to life imprisonment. Of the 20,000 people who who were killed, there were, however, between 5 and 8 survivors, one of whom, unfortunately, was killed during the liberation, and he had survived, we don't know quite how. He was a dentist, but he was shot in crossfire. Those who did survive only survived because they jumped into the septic tanks and emerged from the septic tanks when they thought that it was appropriate and they were safe. But whole families, including babies, were killed in that camp. That camp was one of 190 concentration camps throughout the country. The second case involves the leaders. Nun Chia and Khieu Samphan are the 2 survivors, and they are charged variously with crimes against humanity, genocide, mass murder, persecution, and the like. Certainly the most heinous crimes known to mankind. They have already been sentenced to life imprisonment. The second phase of their trial continues, and it's a very important trial. And to give you an idea of the importance for Cambodia, when the Duik trial was being heard, and at its conclusion, 33,000 people in total had attended that trial. It was the largest number of people to attend any trial in the world at the time. The current trial has had 160,000 people attend, which shows the interest in Cambodia of such trials. It also shows the importance of having such trials, not in The Hague, but rather in the location, so that people can take part. They can see justice being done. I should also say, and I think that our next speaker may talk about this a little bit, one of the major difficulties is, what do you do for victims? And for me, the victim is the centre of the living victim is the centre of the trial. We have within the United Nations consideration impunity from justice. No one who commits one of these offences against humanity should have impunity from justice. That's good. And whether it will deter anyone, I don't think there's much evidence of that personally, because we still have mass atrocity crimes occurring today. But the justice for the victim is really very, very important. And it shouldn't have to wait 30 years as it did in Cambodia. Because if we look at the experience of victims, they have gone from a shattered state where they had absolutely nothing. They've had to cope. They've had to rebuild their lives. And they have managed over a period of 30 years to learn how to do this, how to survive daily, how to get on. And then all of a sudden, a court, a tribunal, rolls into town with a re-traumatisation. Everything that has occurred before, which they were able to at least put to the back of the mind to some extent, is brought forward. What's the effect of that on a person? It has to be appalling. Now, we were, as a group of judges, in a situation which was quite unusual, because the United Nations and the Cambodian government had agreed upon a framework for the operation of the court, but they had not provided, well, the framework was deficient, but they hadn't provided the nuts and bolts. So the judges had to make a difference. We had to get this court operation. And we looked at the law, and the law provided for victims. Victim protection if they were witnesses. And then at the very end of this law, we noticed victims could appeal. And we thought, well, and those of you who are lawyers will know, you can't just come into a case at the end and be an appellant. You have to have been involved at the beginning. So we looked at what we could do. 30 years had gone from the end of the Khmer Rouge period, and there would be no extension of the statute of limitations. So anyone who was a victim could only bring an action within 10 years. So we couldn't do anything there to give them meaningful damages or claims. So what we did was we introduced a system of victim participation, which is French-based, and we said victims could apply to be participants, actual parties to the trials. And we had 4,000 in the second trial, we had 90 in the first, and then we had an additional 4,000 complainants. But we needed to give them some voice in the court so that they would feel that they were participating in a meaningful way. So we provided that they could take part and that we could give them, as judges, if they were successful in applications, we could give them moral and collective reparations. It meant effectively recognition. And that's what most victims wanted. And my court dealt with more than 1,700 appeals of people who'd been excluded. And when they, on their forms, they were asked, what do you want from this? Of all of those people, one or two said, oh, I want my house back, I want my land back. Most said, we want a stupor. We want something to recognise those who were killed. We want recognition for our relatives who died. We want recognition for ourselves. And we, as the applicant victim, we wish to represent our families and our village as victims